Hello everyone, welcome to Employment Tribunal. I am Judge and this is the preliminary hearing between the claimant employee is representing themselves. Hi, yes that's right. And the respondent is being represented by CEO. That's right, I didn't think we needed to get lawyers involved yet. Okay, so the first thing we want to do is go through the case management agenda. I see that both of you have agreed the case management agenda beforehand. That's right, Judge. I and the respondent's lawyers have confirmed the case management agenda, and so we have a copy together. Okay, if we can start with point 1, the names of the parties, and go from there. I'm sorry, Judge, so sorry. Yes, CEO? Could we skip to section 4.2? It looks like that's where we address the fact that we have made an application to strike this whole thing out. I feel like we could probably save a lot of time and just deal with that immediately, and then we can all just go home. I did see that there was an application to strike out. We can get to that point later on. Can't we just do that first? I mean, if we don't need to be here, we don't need to be here, right? This case is very weak, so we could just go ahead and strike it out. That's not really how this works. We don't just strike things out. The claimant would have the opportunity to actually object to the strikeout and then give information that proves that the case isn't worth being struck out. That's right, Judge. I have actually prepared some objections to this strikeout, so I'm happy to just go ahead and talk about it now, or if you would like to take it and consider it later on, happy to go with whatever you want to do. Wait, what do you mean objections? There's no, obviously this stuff didn't happen, and this is all just he said, she said stuff, so they don't have anything that they can... We've told you that this didn't happen, and the lawyers have said that we could just strike it out, so please can we just strike it out? Like I said, that's not how this works. Now, if the claimant is happy for me to consider the strikeout right now, given the urgency that you're placing on the situation, I'm happy to recess for an hour, review their materials and your original strikeout application, and then make a judgment on it. But what do you even need to consider? I don't know what your lawyers told you, but a strikeout is basically saying that the claimant's case has no reasonable prospect of success. That is a very high bar that needs to be cleared. It means that I have to be convinced that there is no evidence that could be out there, no witness statements that could be out there that could mean that the claimant has a potential case. And I do have a list of the pieces of evidence that I will be able to provide later on that will demonstrate that I do have a case that is worth hearing. Thank you. So what I would need to convince myself of is that this well-prepared, organized list of evidence would have no bearing on the outcome of this case, despite the fact that I can see here that there are documents concerning the particular topics, there are witness statements that can be used. I would need to be convinced that there was no reasonable way that these documents could have anything to do with this case. But they have a weak case, that's what I'm trying to tell you. What I'm explaining to you is that this isn't about whether or not the case is weak or strong. It's about whether or not the case has no reasonable prospect of success, that it is dead in the water from the beginning. And examples of that would be, where the claimant had maybe come with no list of evidence, no idea of what their claims were, no real credible story about what happened. I'm telling you, I'm not really seeing that as a problem here. So you're not going to strike out the case? I haven't given my ruling yet, but given that this is a discrimination case which relies so heavily on the facts and evidence of the case, and given that the claimant believes that she does have evidence that is relevant and has them in a well-organized format, I think it's going to be an unlikely outcome. Well, what does that mean that we do now? Now we go through the case management agenda, starting with point 1. We decide what the main legal issues are. We decide how many witnesses need to be called, when you can come for the final hearing, and we get ready for that final hearing and order when disclosure happens and everything else. But I'm not ready for any of that. I thought you were just going to strike the case out. Judge, if I may, the respondent's lawyers have agreed a case management agenda with me, and while CEO might not be party to all of it, we have agreed the list of issues. We do have an agreement on the number of witnesses, so I would argue that we could move forward and work through these points. CEO, do you want to call your lawyers and see if you can get them here? That will cost a fortune. I told them that they didn't need to come because it was going to be too expensive anyway. Okay, well, in that case, do you want to move ahead? Okay, yeah, let's just move ahead. I'm sure this can't be that complicated. Okay, we are now back to section 4.2. Employee, I notice that there is another preliminary item that you would like to file. Yes, I was hoping to file an application for a deposit order on the basis that the respondent's case has little prospect of success. CEO, would you like to object to this deposit order? Wait, what's this deposit order? The claimant is essentially saying that she thinks you have little prospect of success in your defense and is asking for me to order you to pay up to £1,000 in order to continue your defense because they believe that you don't have the evidence to be able to dispute it. Wait, isn't that what we just talked about like an hour ago and you said that you weren't going to do that? No, that was a strikeout application that you did where you essentially said I had no reasonable prospect of success. I'm asking you to pay up to £1,000 to carry on because I think you have little prospect of success. It's a lower bar to hit. So I have to pay you more money? No, you pay the amount to us, the tribunal. And if I find that claimant was correct and you didn't have a prospect of success, then that money would then be transferred to the employee. Okay, well, how do I object to this? I object. That's fine. So I will need your objection and your reasons for the objection. And then I think what I'll do is I'll take 7 days. You'll have 7 days to give me those reasons for the objection. And then I'm going to consider this after the preliminary hearing today. And then I'll write to both of you to let you know if the deposit order fails or succeeds. Same for the strikeout. So I have 7 days to properly object to this. That's correct. Since you do have legal representation, I would suggest that you speak to them and maybe get them involved at the next hearing. Oh, great, more money.